and I'm basically from civil service background. I had also worked as an assistant professor prior to my civil service stint, and currently I am a working faculty with Unacademy, which, as you all know, is the most happening place today in the country in the world of online quality education. And I had also been an NTSE scholar, and I have long been associated now with civil service mentoring and coaching programs for nearly more than 2 decades. And today I have brought a very special topic for you, that is the legislative procedure in a state legislature. If you recall, in my last YouTube video talk, I had spoken about the legislative procedure in Parliament. And to supplement that topic, today now I'm going to talk about the legislative procedure which prevails in case of state legislature in our political system. And as you all know that Parliament basically is passing laws, and laws which are primarily concerned with subjects which are there in the union list, and also in the concurrent list it can make laws on. Same way the state legislature can make laws on subjects which are given in the state list in Schedule 7 of the Constitution. And it can also make laws on subjects which are given in the concurrent list in Schedule 7. And in case if there is a conflict between a union law and a state law on the same subject, then the union law prevails to the extent of contravention or to the extent of that conflict. And the procedure in the case of state legislatures is not very different from the procedure which prevails in Parliament, but still there are quite a few differences. And here today I will highlight for all those students who are preparing for civil service examination and also preparing for state public service exams. Now, since Indian polity now is a current and sort of a universal theme across the exams, so this will be helpful to almost all those students who are preparing for one or the other competitive examination. So let us get going on this. First of all, let me talk about the articles which are concerned with the legislative procedure in the state. So first of all, let me talk about the articles which are concerned with legislative procedure in the states at a glance. The first important article is Article 196 of the Constitution. And Article 196, it talks about provisions as to the introduction and passing of bills. That is how the bill should be introduced and how the bill should be passed. So Article 196, therefore, insofar as the legislative procedure is concerned in the state legislatures, is very important for us. Then 197 is restriction on the powers of legislative council as to bills other than money bills. Now, in fact, bicameral legislature is there in 6 states as of now. That is in Maharashtra, Karnataka, Andhra Pradesh, Telangana, and Bihar and Uttar Pradesh. These are the 6 states in India which have bicameral state legislature. That means they have 2 houses, the upper house, that is legislative council, and the lower house, that is the legislative assembly. And we shall see that the powers, insofar as the legislation is concerned, of the state legislative council, they are rather, not so much, far inferior as compared to the powers which are bestowed on the legislative assembly. And we'll see that, how the legislative council actually plays its role in passing the bills. However, like most states do not have legislative council, and they have a unicameral house or unicameral legislature. And then Article 198, it talks about the special procedure in respect of money bills. And this is a very corresponding article which is there for Parliament. As we know that special procedure is highlighted in Article 109. Here in 198, the similar, very similar procedure is highlighted in the Constitution for passing the money bills in the state legislatures. And 199, it talks about the definition of money bills. And we know that a similar article, corresponding article is there, that is 110 in the case of Parliament. So 198 and 199, these two articles are very specific, and they talk about the procedure and the definition respectively for the money bills. Article 200, it talks about the assent to the bills. Assent is to be given by the governor to a bill which has been passed by either one or both houses of state legislature. And 201, it talks about the bills which are reserved by the governor for consideration of the president. There are special situations when the governor can reserve a bill for consideration of the president. For example, like if the bill is derogating the powers of the High Court, or it is endangering the powers of the High Court in any way, or if it is ultra vires of Constitution, or it is anti-national in character. Like there can be several instances where a bill can be reserved by the governor for consideration of the president. That is highlighted in Article 201 of the Constitution. And Article 202, it talks about the annual financial statement, which is same thing as budget. So the state budget, as you know, that's like just like the central budget, state governments are also presenting their budget in the legislature, and particularly the presentation is done in Legislative Assembly. And here again, the powers of the Legislative Council are very limited, and we'll see that what are the limitations of the powers of Legislative Council. And annual financial statement, just like Article 112 is there for Parliament, here this 202 is there for the state legislatures. And Article 203 talks about procedure in legislature with respect to estimates. So various ministries are preparing their estimates, and these estimates are eventually presented in the legislature in the form of demands for grants, which are then passed by the Legislative Assembly. And appropriation bill, basically all these demands for grants, they are then consolidated into an appropriation bill which has to be passed in order that the government is enabled to incur expenditure out of the consolidated fund of that particular state. So appropriation bill provisions are there in Article 204. 205 talks about supplementary, additional or excess grants. Now these are financial terms. When a grant is supplementary, basically it means that it is supplementing the existing grant. In other words, it is basically meant for the same purpose, but when extra or supplementary amounts are required for that particular purpose, then supplementary grants are moved. Additional grants are moved if there is a new head or a new work is there. Under a new head or new work, when expenses are to be meted out or required, then additional grants are required. And excess grant is required in case if the state executive has incurred more expenditure or expenditure in excess of what was granted by the state legislature earlier, then excess grants are required in order to get that regularized. Vote on account is basically till the budget is passed, expenses are to be authorized to the government, and for that purpose, vote on account is passed after general discussion. And vote of credit, when no proper estimates can be made and one doesn't know as regards the accuracy of the estimates, then vote of credit is passed. It's like a blank check, and then subsequently, of course, it is to be presented back to the legislature for approval. Exceptional grants are there for exceptional purposes. Then this is Article 206. Then Article 207, it talks about the special provisions as regards of financial bills. Special provisions regarding the financial bills are there in Article 207. Then as far as the procedure is concerned, all these articles 208, 209, 210 and 211, 212 and 200, these are all concerned with the procedures. Like the procedure, rules of procedure are highlighted in Article 208. Regulation by law of procedure in the legislature of the state in relation to financial business, that is in 209. Language to be used in the legislature 210, and restriction on discussion in the legislature insofar as the conduct of judges is concerned, that is 211, and courts not to inquire into the proceedings of the legislature, that is given in 212. And Article 213 is very special article, just like 123 is there for the ordinance making powers of the president. Article 213 is there, which is the ordinance making powers of the governor. So these are the powers of the governor to promulgate ordinances during recess of the legislature. Now this is important. This is a very exclusive power which is given to the governor, that when the legislature of the state is not in session, either one house or both the houses are not in session, then the governor under Article 213 is authorized to promulgate ordinances. And those provisions are given in Article 213. So legislative procedure of the states in general, if we talk about, first of all, let us talk about the ordinary bills. Bills in the originating house. If we talk about that, an ordinary bill can originate in either house of the state legislature, as is the case in Parliament. And in case of a bicameral legislature, it can be introduced in either house of the state legislature, and such a bill can be introduced either by a minister or by any other member. So either a minister can move the bill, then in that case it will be a public bill, or any other member of the state legislature can move the bill, then it will be called a private member's bill. And the bill passes through 3 stages in the originating house. First, there are 3 stages, as is the case in Parliament. Similar case is there in the case of state legislature. First reading is there, second reading is there, and third reading is there, right? And this first reading is basically the objectives of the bill are read out, and its publication takes place in the Gazette after, of course, the conduct of business committee that has approved it, and then it is introduced. And then first reading basically means that objectives of the bill will be read out and its publication in the Gazette will be ensured. And then second reading is important stage where, first there will be a general discussion. General discussion will be there. Then generally the bill is referred to a committee, and then committee examines that, and then again it comes back to the House, and the House, in details, clause by clause, it discusses the bill, and voting is done, clause by clause. Amendments are also moved. And then finally, in the third reading, the bill as a whole is voted by the House. So these are the 3 readings, and here, after the bill is passed by the originating House, it is transmitted to the second House for consideration and passage. And a bill is deemed to have been passed by the state legislature only when both the houses have agreed to it. So it is necessary that in case of bicameral legislature and ordinary bills, both the houses must agree to it, either with or without amendment, right? Both the houses must agree to it. In case of a unicameral legislature, a bill passed by the Legislative Assembly is sent directly to the governor for his assent. So that is normally the scenario, that a bill is passed by one house, it goes to another house also passes the bill, then the bill goes to the governor. In case of a unicameral legislature, one house passes the bill, it goes to the governor directly because there is no other house, and then the governor gives his assent and it becomes a law, state law. But of course, as far as the other house, that is the Legislative Council, is concerned, its powers are very limited as regards the bills, passage of bills. The maximum it can do is delay a bill by 4 months, 3 months in the first instance and 1 month in the second instance. And then eventually, like if 4 months time lapses, then and still some disagreement is there, the bill is deemed to have been passed by both houses of the state legislature. So bill in the second house, if we consider the bill in the second house also the bill passes through all the 3 stages. That is the first reading stage, second reading stage, and the third reading stage, which I explained to you just now. And when a bill is passed by the Legislative Assembly and transmitted to the Legislative Council, the Council has really 4 alternatives for it. Number 1 is that it may pass the bill as sent by the Assembly. In that case, there is no problem. It is just, it receives the bill, it passes the bill without any amendments. Then it goes to the governor and it becomes a law. Second is, it may pass the bill with amendments and return it to the Assembly for reconsideration. This is another option which it can do. And then, of course, the amendments which have been suggested by the Council, when it goes to the Assembly, Legislative Assembly, they may accept these amendments and pass the bill, send it to the governor, then the bill becomes a law, right, up to the assent of the governor. But if suppose assembly doesn't accept these amendments, right, and it passes again that bill without those amendments and sends to the council, then the council in the second instance can delay this only by 1 month, right. So and even then, in 1 month also it doesn't pass the bill, then the bill is deemed to have been passed by both houses of parliament, both houses of the state legislature. Now it may reject the bill in the its third option is it may reject the bill altogether. But even in that case, even if it rejects the bill, it doesn't matter. The will of the legislative assembly prevails eventually, and the bill is deemed to have been passed the way it was passed by the legislative assembly. And it may not take any action and thus keep the bill pending. And there it can dilate or delay the bill by maximum 4 months, or in the first instance 3 months. It doesn't take any action. Then the legislative assembly will pass the bill and then send to the governor. So let's see stage by stage, like if the council passes the bill without amendments, right, or the assembly accepts the amendments suggested by the council, the bill is deemed to have been passed by both houses, and the same is sent to the governor for his assent. So it's a cakewalk, simple situation. There's no conflict, and the amendments have been suggested by the council, and it goes to the assembly, and the assembly accepts the amendments, and then it goes to governor. So this is a very straightforward situation. Now another situation, on the other hand, if the assembly rejects the amendments which are suggested by the council, right, or the council rejects the bill altogether, council may altogether reject the bill, or the council does not take any action for 3 months. For 3 months it doesn't take any action on the bill. Then the assembly may pass the bill again and transmit the same to the council. In all these three situations, the first situation, let me repeat, if the assembly rejects the amendment suggested by the council, right, it is rejected, and rejected those amendments and passed the bill and sent it to the council. The second is council rejects the bill altogether. Council has rejected bill altogether. Then, or the council does not take any action for 3 months. In all these three situations, assembly may pass the bill again and transmit the same to the council. Now, if the council rejects the bill again or passes the bill with amendments not acceptable to the assembly, or does not pass the bill again within 1 month, then the bill is deemed to have been passed by both the houses in the form in which it was passed by the assembly for the second time. When it was passed by the assembly for the second time, then it is deemed to have been passed, in that form. So that means that legislative assembly has got overriding powers insofar as the passage of bills is concerned. I'm talking of the ordinary bills. And there is a special procedure highlighted, as I just now mentioned, for money bills. And here, like we had seen those articles, that a special procedure is highlighted here. Articles 198 and 199. These two articles, they specifically talk about the money bills. 198, it delineates a special procedure for the money bills, and 199, it talks about the definition of money bills, of course. There, the Speaker of the Legislative Assembly's decision is final to decide whether a bill is a money bill or not. So in this instance, therefore, what we say that in all these cases, therefore, the ultimate power of passing an ordinary bill is vested in the assembly, right? At the most, the council can detain or delay the bill for a period of 4 months in all. 4 months. 3 months in the first instance and 1 month in the second instance. 3 months in the first instance, 3 months, plus 1 month in the second instance. Total, it can delay the bill by 4 months. So we can see that the powers of the council, legislative council, are very limited insofar as the passage of ordinary bills is concerned. And insofar as the money bills are concerned, of course, its power is still more limited, because those bills, in case if it doesn't take any action or it suggests certain, recommendations, make certain recommendations, it cannot amend the money bills, but it can make some recommendations. And if it does so within 14 days, it is up to the assembly to accept or reject any or all of those recommendations. And within 14 days, if it doesn't take any action, then too, the bill is deemed to have been passed by both houses of the state legislature. So that is a special procedure which we just now had seen. And this is about the procedure which we have seen just now, that is of the ordinary bills. And the Constitution does not provide for any mechanism of a joint sitting of both the houses to resolve any disagreement between the two houses over a bill. See, there is a provision of joint sitting insofar as Parliament is concerned, the two houses of Parliament. If there is a conflict between Lok Sabha and Rajya Sabha, then there is a provision under Article 108 for joint sitting, right? But no such corresponding provision for joint sitting is existing in the Constitution in the case of state legislature, because the will of the assembly prevails eventually. All the council can do is maximum it can delay a bill by 4 months. And within 4 months after the bill has been passed, within that period of 4 months for the second time by the legislative assembly, then that is deemed to have been passed by both houses of the state legislature. And on the other hand, there is a provision for joint sitting in the Lok Sabha and the Rajya Sabha to resolve a disagreement between the two over an ordinary bill. So we understand that Article 108, it talks about the joint sitting, which is presided over by the Speaker of the Lok Sabha. But there is no similar or corresponding article for joint sitting insofar as the state legislature is concerned. Moreover, when a bill which is originated in the council and was sent to the assembly is rejected by the assembly, then the bill ends and becomes dead, because ultimately assembly is supposed to pass it, and the will of the assembly prevails in the case of disagreement also. But if the assembly in the first instance, a bill which originates in the legislative council and it is sent and transmitted to the legislative assembly, and the assembly rejects it right in the beginning, then that is the end of the bill. The bill is dead, and that ends the bill altogether. Therefore, the council has been given much lesser significance, position, and authority. So the legislative position of the legislative council is on a much lower pedestal than that of the assembly, and also it is much lower than that of the Rajya Sabha at the center. So Rajya Sabha is the upper house in Parliament, and here the council is the upper house in the state legislature. But its position, insofar as the passages of bills are concerned, is much inferior to the position of the Rajya Sabha. That is one important point to understand. So before I proceed further and we examine the procedures concerned with the money bills, and also examine the similarities and differences between parliamentary procedure and the legislative assembly procedure, let me just go through very quickly. Now, we are going to have this mega combat, which is very useful for all the candidates. That is on 23rd of January, 11 a.m. There you are supposed to answer 56 questions in 1 hour, and you become entitled for a whole lot of prizes on offer. That is iPad mini or MacBook or iPhone or Amazon vouchers, all are there. But all you have to do is you have to make use of the referral code VN10. VN10 is my referral code. With this referral code VN10, you will become entitled for a free entry into Mega Combat in the first place. And of course, it will also entitle you for scholarships, right? So this is high time for you to actually, there are, 4 lakh plus test takers and 50,000 plus winners. So this is a great opportunity for all those candidates who want to get registered with Unacademy at this time, because this is the right time. Why am I saying so? Because this is the time when you are being offered, great incentives, and this is one of the incentives. Then there is 18 months combo offer is there. 18 months combo offer where you save nearly 20% money, right? 20% money on the original price is nearly 80,000, but you will have to pay only 64,000. And this is a great offer because it will also entitle you for free books, right? Nearly 20,000 worth of books will be provided for free. 3 months extension is admissible. Test series for free is available with that, and 3 months free extension is available. But this was valid only up till 19th of January, till yesterday. So you will have to check on the Unacademy site whether this has further been extended. Otherwise, in any case, 18 months combo offer is valid, and this extra 10% off for and 3 months free extension is there. So that is there. Then you can check, whether it is coming with 3 months extension now, or it is coming merely with 20% discount. But for that also you will have to use this code VN10. It is victory like never before with 10 times the force. This is the full form I have given to it. Then of course you might have seen in the recent IAS results also, Unacademy has shown exceptional performance, and all India rank 2 of Jagriti, Avasthi, Apala Mishra, Satyam Gandhi, Gaurav Budhania, Karishma Nair, and Arth Jain, and Podisheti Shrija. Now, all these brilliant candidates who have made it to the top rungs of civil service, they are from Unacademy. And in all, it had given more than 170 selections in the last results civil services. So what I'm saying is that Unacademy has proven its mettle and worth, and this is high time for you to join. One of the great reasons for the great success of Unacademy is the association of very highly experienced and great mentors and educators. So you can make out, for example, now I've got an experience of more than 25 years in teaching and mentoring IAS programs, and I was also associated with Vajiram and Ravi for some time. And so what I'm saying is that this is one of the biggest reasons for the success of Unacademy, that it has great educators, and you will have the opportunity to have access to these great educators. So it's high time you decide to enroll and register yourself. Then, of course, 19th of January, since yesterday, we already started the whole lot of batches for Mission 22, Lakshya 22. And here you can see all the topmost educators of the country. Rakesh Verma, who is also from civil service background, like I'm from civil service background, Sachin Arora from geography, Ramesh Singh, you might have read his book on Indian economy, and Murnal is there, and Rajneesh is there. The whole lot of professors, Siddharth is there, Sudarshan is there. A whole lot of great mentors are now there, and you can have a choice and to attend the classes. And all you have to do for that is register yourself for the subscriptions at the earliest possible time. Now, at the same time, you can see that the optional courses we are starting this month, January, a whole lot of courses in philosophy, Avinash Sinha sir, history also, Ranganathan, and public administration, Rakesh is there, and geography, Sachin Arora, and a whole lot of Deepika ma'am is there for PSIR. So a whole lot of great educators. You'll find sociology, Ankit Kumar is there. So Vamshi Krishna is there for sociology in English. So what I'm saying is that this whole spectrum of civil service optional courses, they are now like to a great extent available, and you can have direct access after subscription. Now, also, if you are short of money or finances, then you can also go for loan facilities available with no processing fee and 0% interest rate and flexi tenures. So all these facilities, I don't think that any other coaching platform is offering financial aid to students who are in financial distress or are in need of money. So if you want to become an IAS officer and you don't have sufficient money with you, this is high time you can avail of this loan facility as well. Iconic subscription, by paying some extra amounts, you can avail of Iconic subscription. It enables you to have live mentoring, a study planner, and open house with educators. So I think these are great facilities which are being offered by Unacademy at a very, very reasonable price. If you compare the subscription rates or the prices of Unacademy with other national level coaching institutes, you'll find that this is less than half. And quality wise, this is more than 10 times. For the simple reason that, great educators with great experience are now associated with Unacademy. And for the simple reason that millions of students are now flocking Unacademy platform. and that is because of its high quality content and great educators being there on the platform, and more importantly, like quality test series. There is a lot of emphasis on test series and quality test series, and also you will get to have practice for mains answer writing, and I think that is something which is very rare in many coachings. It is not there. So what I'm saying is that this is high time for you. You can therefore decide and join quickly. Now let's talk about assent of the governor. Now every bill, after it has been passed by assembly or by both the houses in the case of bicameral legislature, which I stated that only 6 states in India, of course, 6 states like Maharashtra, Karnataka, Andhra Pradesh, Telangana, and Uttar Pradesh and Bihar. Of course, for Tamil Nadu also, Parliament had passed that act for the creation of council, because Article 169, it talks about creation or uncreation or abolition of the council. But there, in the case of Tamil Nadu, the assembly had first passed that resolution by special majority, sent to Parliament. Parliament enacted for that, but in the meantime, they had gone back on it, and so they have not implemented it. So what I'm saying is that 6 states are having the council, and when it has been passed by both the houses in the case of bicameral legislature or by the single house in case of unicameral legislature, the bill is presented to the governor for his assent. Now here in the case of states, governors have enormous powers. They have enormous discretion also. So there are 4 alternatives governor can utilize. He may, for example, give his assent to the bill. Then of course bill becomes an act or a law. Or he may withhold his assent to the bill. Then nothing can be done about it. It doesn't become a law. And he may return the bill for reconsideration of the house or both the houses. Yes, that possibility is there. And 4th is that he may reserve the bill for consideration of president. I told you there are several instances and there are several bases on which a governor is entitled to reserve a bill for the consideration of the president. Now particularly, like as I said, that if it is derogating of the powers of the high courts or endangering the powers of the high court, or if it is ultra vires of constitution, or it is anti-national in character, right? So in all such instances, that bill can be reserved by the governor for presidential consideration. President will consider, send it back to governor, either giving his assent or not giving the assent, or even he may send it for reconsideration. But after second time also, if the house or the house has passed that bill and send it back through governor to the president is not bound to say yes. That means president exercises a kind of veto, right? He can exercise a kind of veto over the bills of state legislature. So that is an added or kind of protective cover which has been provided in our constitution. So if the governor gives his assent to the bill becomes an act, and is placed on the statute book, obviously. And the governor withholds his assent to the bill ends and it does not become an act, as I said. And if the governor returns the bill for reconsideration, and if the bill is passed by the house or both the houses again, with or without amendments, then and presented to the governor for his assent, the governor must give his assent to the bill, right? So here there is a specific provision that in case if it is passed for the second time, then governor has no option, but he must give his assent to the bill. Thus the governor enjoys only a suspensive veto, and the position is same in the case of at the central level also it's a similar position. And as far as the assent of the president is concerned, if we talk about that, when a bill is reserved by the governor for consideration of the president may either give his assent to the bill or withhold his assent to the bill, or return the bill for reconsideration of the house or the houses of the state legislature. When a bill is so returned, the house or the houses have to reconsider it within a period of 6 months, right? Maximum they have to reconsider within a period of 6 months, and the bill is presented again to the president for his assent after it is passed by the house or houses with or without the amendments. And it is not mentioned in the constitution whether it is obligatory on the part of the president to give his assent to such a bill or not, right? So it is presumed that president may still decline. So money bills, so far as the money bills are concerned, The Constitution lays down a special procedure, as we all know, for passing of the money bills in the state legislature. We just now seen these articles. And money bill cannot be introduced, first of all, it cannot be introduced in the council. It can be introduced only in the legislative assembly, and that too on the recommendation of the governor concerned. And every such bill is considered to be a government bill, and it can be introduced only by a minister. And after a money bill is passed by the legislative assembly, it is transmitted to the council for its consideration. And here again, council has restricted powers, very restricted powers with regard to a money bill. It cannot, for example, reject or amend a money bill. All it can do is it can make some recommendations and must return the bill within 14 days to the assembly. And the assembly can either accept or reject all or any of the recommendations of the council. And if the legislative assembly accepts the recommendations, the bill is then deemed to have been passed by both houses of the legislature in a modified form. But if the legislative assembly does not accept any recommendation, then also the bill is deemed to have been passed by both houses of the legislature in the shape in which it was originally passed by the legislative assembly without any change. So here we see that the assembly has overriding powers over the council, and maximum it can delay is for 14 days. So if the council does not return the bill to the assembly in 14 days, the bill is deemed to have been passed by both houses of the assembly, right, at the expiration of the set period in the form originally passed by the legislative assembly. So again, here we find that assembly has got overriding powers even in this case. Then, so the legislative assembly has more powers than the legislative council with regard to money bill. At the most, the legislative council can detain or delay the money bill by a period of 14 days. Then finally, when a money bill is presented to the governor, he may either give his assent to the money bill or withhold his assent. Or third option is that he can also reserve the bill for presidential assent, but he cannot return the bill for reconsideration. He cannot return the bill for reconsideration. He can either give his assent or deny his assent, means reject, either accept or reject, or he can reserve it for the presidential consideration, but he cannot return it. Normally, the governor gives his assent to a money bill as it is introduced in the state legislature only with his prior permission, right? And when a money bill is reserved for consideration of the president may either give his assent to the bill or withhold his assent to the bill, but he cannot return the bill for reconsideration of the state legislature. If it is a money bill, then president also cannot return it for reconsideration. Either he has to accept it or reject it. Now, if we see in this table comparing legislative procedure in parliament and the state legislature largely as regards the ordinary bill, we see mainly ordinary bill, if there is a conflict between the two houses, then there is a provision in parliament for joint sitting, but there is no such provision in the case of state legislature. Other than that, largely the procedures are more or less the same. So I will not go into finer details of this, but as you can make out that more or less it is the same. But yes, we can just scan through in order to understand that for the ordinary bill, for example, in the state legislature, it can be introduced in either house of the state legislature. It can be introduced in either by a minister or by a private member, and it passes through first reading, second reading, and the third reading in the originating house, and then it is deemed to have been passed by the state legislature only when both the houses have agreed to it, either with or without amendments. Or a deadlock between the two houses takes place when the legislative council, after receiving the bill passed by the assembly, rejects the bill or proposes amendments that are not acceptable to the assembly, or does not pass the bill within 3 months. Right? In that case, the constitution does not provide for the mechanism of joint sitting of the two houses in the case of state legislature to resolve a deadlock between the two over passage of a bill. And the legislative assembly can override the council, as I already suggested, by passing the bill for the second time and not vice versa. So when a bill is passed by the assembly for the second time and transmitted to the council, if the council rejects the bill again or proposes amendments that are not acceptable to the assembly or does not pass the bill within 1 month, then the bill is deemed to have been passed by both houses in the form in which it was originally passed for the second time by the assembly. And that is the main difference here. And the mechanism of passing the bill for the second time to resolve a deadlock applies to a bill originating in the legislative assembly only. Right? When a bill which is originated in Legislative Council and sent to the Assembly is rejected, then of course the bill becomes dead. It comes to an end, right? Similarly, for the money bill, we can see that very similar procedure is there for money bills, and Assembly has got overriding powers insofar as the money bill is concerned. Briefly, I can just scan through this, that it can be introduced only in the Assembly and not in the Council. And it can be introduced only on the recommendations of the governor, and it can be introduced only by a minister, not by a private member. And it cannot be rejected or amended by the council. All it can do is, it can make recommendations within 14 days. And those may or may not be acceptable to the Assembly. And eventually within 14 days, if nothing happens, the bill is deemed to have been passed by both the houses of the state legislature. Then this is about, at the same time, if the Legislative Assembly does not accept any recommendation, the bill is then deemed to have been passed by both the houses, as they already stated. If the council does not return the bill to the Assembly within 14 days, then the bill is again deemed to have been passed at the expiration of that period, right? And the Constitution does not provide for the resolution of any deadlock between the two houses, and this is because the will of the Legislative Assembly is made to prevail over that of the council. And if the latter does not agree to the bill passed by the former, obviously, that we already stated and understood. So students, that is the position as regards the ordinary bills as well as the money bills, and we see that overriding powers are there with the Assembly. We also see that as far as Rajya Sabha is concerned, the comparison of the Legislative Council with the Rajya Sabha also is such that it is at a much lower pedestal, a much less significant. Legislative Council is much less significant than Rajya Sabha, right? For the simple reason that Legislative Assembly has overriding powers and there is no provision for a joint sitting. So these are some of the basic differences between the two, and we have also seen that for ordinary bills as well as for money bills, Legislative Assembly has got overriding powers. And now, position of the Legislative Council, if you see the constitutional position of the Council is compared with the Assembly, can be studied from two angles. Spheres where the council is equal to the Assembly and spheres where the council is unequal to the Assembly. Now, equal with the Assembly, if we see, there are certain matters, the powers and status of the council broadly are equal to that of the Assembly. What are these matters? For example, introduction and passing of ordinary bills. However, in case of disagreement between the two houses, the will of the Assembly prevails, right? And approval of ordinances issued by the governor. So when ordinances are issued by the governor, they are to be approved, and this approval, they are on equal footing as far as that is concerned. Selection of ministers, including the chief minister under the Constitution. The ministers, of course, ministers, including the chief minister, can be a member of either house of the state legislature, either of the Assembly or the council. However, irrespective of their membership, they are responsible only to the Assembly. And consideration of the reports of the constitutional bodies like the State Finance Commission, State Public Service Commission, and the C&AG, they have equal powers in that. And enlargement of the jurisdiction of the State Public Service Commission, for that also they have equal powers. And unequal with the Assembly in several instances. For example, money bills can be introduced only in the Assembly, not in the Council. And Council can at most delay it by 14 days and cannot do much more than that. And the Assembly can either accept or reject all or any of the recommendations. In the case of money bills, of course, overriding powers are there with the Assembly. And final power of passing an ordinary bill also lies with the Assembly. As we have already seen, maximum it can delay is by 4 months, right? So it is more of a dilatory house. It cannot, do anything more than that. 3 months in the first instance and 1 month in the second instance. So in other words, the council is not even a revising body like the Rajya Sabha. Right, it's not a revising body. It cannot, make amendments which are, then there is a deadlock, then there is a provision for joint sitting. So it can be a revising house, Rajya Sabha. But a council, Legislative Council, is not even a revising house. It is only a dilatory chamber. It can delay maximum, or an advisory body, or advise, make recommendation. The council can only discuss the budget, but it cannot vote on demands for grants, for that matter. And the council cannot remove the council of ministers by passing a no confidence motion. This is because the council of ministers is collectively responsible only to the Assembly and not to the council. But the council can discuss and criticize the policies and activities of the government. Similarly, Now, when an ordinary bill which is originated in the council was sent to the assembly and rejected by the assembly, the bill ends there and it becomes dead. So here also we can see the overriding powers of the Legislative Assembly. The council does not participate in the election of the President of India and representatives of the state in the Rajya Sabha, right? So as far as the election of the president is concerned, council doesn't participate in that. It doesn't also participate in the indirect election of the members to Rajya Sabha from that particular state. There also assembly has an upper hand. And the council has no effective say in the ratification of a constitutional amendment bill. In this respect also, the will of the assembly prevails over that of the council, right? And finally, the very existence of the council depends on the will of the assembly. The council can be abolished by parliament on the recommendations of the Legislative Assembly. But of course, under Article 169, they have to pass a resolution by a special majority of total membership of the House plus 2/3 of the members present and voting. Then it can recommend to Parliament abolition or creation, right? If it is already created, abolition. If it is not there and wants to create that, creation. To the Parliament, and the Parliament, of course, then has to pass that bill to that effect, and then, the House is created or uncreated. So it is clear, therefore, that the position of the Council vis-a-vis that of the Assembly is much weaker than the position of Rajya Sabha vis-a-vis the Lok Sabha. So Rajya Sabha has equal powers with the Lok Sabha in all spheres except in financial matters and with regard to control over the government, because government is responsible. The Council of Ministers, as per Article 75, Clause 3, is responsible to the Lok Sabha, right? And on the other hand, the Council is subordinate to the Assembly in all respects. Thus, the predominance of the Assembly over the Council is fully established. So we see the legislative procedure is such that the Assembly has got predominance over the Legislative Council. So, friends, with that, I will bring this video talk to an end. Please remember my referral code VN10, which will entitle you for, as of now, 20% discount. Otherwise, in general, it will entitle you 10% discount, and also a free entry into the combat, and also it will entitle you for a lot of other benefits on the Unacademy platform. You must decide to join, use the referral code, and join and have access to experienced and brilliant mentors. And of course, you can certainly, with that, what I'm saying is that you can achieve and realize your dream of becoming an IAS officer. So I wish you all the very best of success in the meantime. Thank you so much, and follow me up on my other videos also on interesting themes. I will come up with more videos, right, in near future. So thank you so much.